Okay, we are going to go ahead and get started. I'm Pam Bridge, and I'm joined today by Stan Silas. He is a lead attorney in our housing unit at CLS. As you know, these are part of our ongoing webinars concerning legal issues during COVID-19. Next week, we normally do these on Thursday and Friday, and on Wednesday and Friday, but next week we're gonna do a little change just because of our speaker's schedule. But we will be doing it on Thursday at lunch, and it's the laws concerning going back to work. So many people are going back to work right now. There's a lot of laws that impact that. So that's what we'll be doing Thursday at lunch, and then landlord-tenant issues on Friday. You can always join these webinars by signing up at www.clsaz.org/events. During this, you can always write questions in the Q&A. We will get to those questions at the end of the PowerPoint. Feel free to ask questions. We can answer any legal information like what does the law say. However, if you're looking for legal advice, if you want to talk to us about your situation, then we would need you to apply for services at CLS. And you can do that by calling us Monday through Friday, 8 to 3. However, even if you don't ask questions about legal information, you can always email us with just legal information questions, and Stan and I are happy to do that. So let's take it away. Air conditioning issues are so important every summer. This is an ongoing issue we get every single summer. A lot of legal aid programs are discussing this because there are some little differences with COVID-19. So it's good for everyone to understand your rights and responsibilities concerning air conditioning issues here in Arizona. And also a couple of the changes because of COVID-19. So first, let's talk about the landlord responsibilities before and during COVID-19. So these are things that the landlords were required to do before we had this pandemic, and they continue, even despite the pandemic, to be part of the landlord's responsibilities. A landlord has to repair and do whatever is necessary to put and keep the premises in a fit and habitable condition. A landlord has to comply with all city and state building codes that materially affect the health and safety of the premises, and we will talk about that in a minute. Maintain in good and safe working order all electrical, heating, ventilating, and AC systems, and supply a reasonable amount of heat, AC, or cooling where such units are installed and offered. Stan, do you want to add anything to that before we move on?
I would just say if you're an advocate and you're trying to help your client and you're looking at ways to see what the landlord is responsible for providing under the statute, it would be 33-1324. That's the foundational piece of the statute where the landlord has statutory obligations regarding the premises and towards your client. So always look there to see what the landlord's duties are under the Landlord-Tenant Act. ARS 33-1324.
So how hot is too hot? Well, first of all, like we just said, if something is broken and the air conditioning is not working, then the landlord has to fix it, despite what the temperature is, despite whether it's summer or 100, the landlord has to fix it. However, in addition, you saw that they also have to apply with city codes. In Phoenix, so each city in Arizona has different codes about how hot, what the air conditioning and swamp coolers have to be set at. So you need to look at your city codes. For example, in Phoenix, swamp coolers must cool to 86 degrees and air conditioning to 82 degrees. So does that mean that because your air conditioning is working at 80 degrees, that's fine? No, it's not. If it's not working, the landlord has to repair it. This just means that they also are violating a city ordinance. Stan, do you want to add to that?
I would add to it, as Pam just said about the city ordinance, is that it's so important that if your clients believe that he or she is in a situation where the AC is not working properly, to reach out to your local building code department and try to have them come out and conduct an inspection and determine that in fact that AC is not meeting the building code standards in that particular municipality. Having them come out, make that inspection, make that determination, then they will write it up, submit it to the landlord or property manager. They'll have so much time to address the violation, and that gives the tenant a considerable amount more of leverage to try to get the repairs made and made in a timely manner than just trying to do it alone.
Where we've seen this before is when there's been a dispute between the landlord and the tenant about whether the air conditioning is working or not, right? So at least this gives definite proof, like what Stan said, having someone look at it. Again, if it's not working and you're hot, people should never put their health in danger. Then they can do the things that we can talk about looking for remedies. All right, so a lot of people, you know, when tenants come to CLS, will say, well, did you give notice? And they'll say, well, they know. And like, well, you need to make sure that you've given notice. The law actually says to give the landlord written notice of lack of air conditioning, and CLS and the courts always suggest that that is written notice. Why do you want it in writing? Because you want to have proof, right? If you want to make sure. Normally, this is a 5-day notice, and we'll talk about when it might be a little bit different. But for air conditioning, normally it's a 5-day notice to your landlord telling him it's not working and giving them an opportunity to fix it. Just like when a tenant has a violation, the landlord has to give the tenant a notice in writing and an opportunity, we call it opportunity to cure, opportunity to fix the air conditioning. You can text or email this and make sure you keep a copy. Right now, we understand in the middle of our pandemic, tenants can't reach the landlords, they can't mail, it's difficult to go and hand deliver information. So you can text and email right now. Stan, do you want to add to that?
Definitely. The old-fashioned written notice makes a lot of sense because you got proof, especially if you send it certified mail, registered mail, you got proof that it was sent. Or if you send it by text or email, as Pam said, you got to be able to prove that, because later on at the end, I'm going to document how important it is that you provide good notice, because the landlord is not required to do anything until you can demonstrate you gave him or her notice of the violation and then a chance to cure it. So it's really important that you can prove in a justice court by yourself, probably, that this is in fact what happened. Also, you want to make sure if the landlord gets the notice, you allow them to begin to do the work. You don't want to be caught in a situation where it's deemed that you have denied them access. So once you make the request, you got to be prepared to let them come in and make the repairs. Doesn't mean they come in at 12 o'clock at night, but it does mean you got to be reasonable. You got to let them in. You don't want to get caught in a situation where it looks like you denied them access, because then you're not going to get anything done, and you're going to have a violation against you for denying the landlord access to make these repairs.
So some good news, CLS has a whole brochure on our website, www.clsaz.org. And then we have sample notices. If you go to the housing page, and there's a little thing you can hit that says what to do if my air conditioning is not working, you can find all of these notices to give your landlord. And this is just one of the notices. This follows what the courts also give, the sample notices that the courts give out, but it lets you know about your options. You got to choose your options of what you want to do to remedy the situation. And we're going to go through each of these options one by one. So option one. Option one is that you can give your landlord a written notice that they have 5 days to fix it. And if they don't make the repair, if they don't fix the air conditioning, then you can decide to terminate your lease and leave. You will be responsible for any rent during that time, And you need to give your landlord a notice of your move out date. We have a copy of that notice also on our website. So we always tell tenants, a lot of times tenants will think, well, I'm just done with the situation. I'm just going to let them know I'm moving out. Before you give them that notice and you state that, you make sure that you understand you have a place to go, that you understand that you're going to have to pay a deposit somewhere else, that you're going to have moving costs, because what can't happen is that you give the landlord a notice that you're going to leave and then you change your mind, because the landlord will hold you to it. We've seen that happening right now with leases ending. So if you give your landlord a notice that you're going to leave, your tenancy will be terminated then. So don't do it if you're not sure you have a place to go or you're not sure you can afford to move. Stan, you want to add to that?
Other thing there is to be aware that if you exercise this option, you are now probably going to put yourself in a situation where if you're going to make a request for your security deposit back, that may be a little bit more difficult, because the other side may say, well, you breached the lease. We have so many more months left on the lease. I'm going to withhold the security deposit to offset my damages. So just be aware, once you take this option, which you certainly are entitled to, it will have ripple effects.
So the good news is that people used to think that if you give notice to your landlord to fix something, that you had to terminate your lease. And that's just not true. This is only one option. You have many more options as a tenant. Number two, you can sue the landlord. We don't see this very often by tenants not represented. So we would suggest that if this is an option that you would like to consider, that you talk to an attorney. These are issues that CLS works on all the time. So what can you do? What can you sue for? First, you have to give the landlord a notice that says they have 5 days to make the repair. If they don't make the repair timely, then you can file a lawsuit, an injunction, and that would be in Superior Court, to force the landlord to fix the air conditioning and for your monetary damages. So you're basically saying, I need this air conditioning fixed. You're not moving fast enough. This isn't getting done. This is life-threatening for me. It puts me and my family at jeopardy. I'm going to go into court and get an injunction. Again, this is something we do not see very often, if ever, by pro-per tenants. So we really would suggest at that point that you reach out to an attorney. Okay, another option you have is if the landlord does not make the timely repair, you can sue the landlord to recover for the reduced value of your home from the deadline stated on the notice until the air conditioning was restored to your home. That is going to be, you're still going to owe rent, but you can sue for reduced value of your unit because you don't have full access of your unit if your air conditioning is not working right now. If you are going, it says contact justice courts, but if you are going to go into the justice courts for a lawsuit for reduction of your rental value, or you're going to go to the Superior Court to try to get an injunction, you got to call them right now, like we've talked about in our other webinars, because everybody's operating differently. There is a court order that says beginning June 1st, the courts are going to start transitioning away from doing phone hearings to doing more in-person hearings. So if this is an option that you want, you need to contact the court to find out how they're operating. Stan, you want to add?
Yeah, I do. Point number 2 about the diminution in rental value. That's a very sort of tricky proposition. Meaning this, it's now a contract claim. Pam said you can sue for the diminution in rental value to your home because the fact that you're paying $800 a month in rent, your air conditioner's been out for a week. So you might be able to make the argument that, well, that's about $250 of lost value for my dwelling unit. But you got to bring that as a contract claim over in justice court, small claims matter, if you will. You got to represent yourself. The landlord may be a corporation, they may have, or an LLC, they may have legal counsel. So you may be going up against an attorney, or you may be going up against a pro per landlord. But the point is, that's a separate claim that you're going to have to represent yourself in justice court, trying to show the court that you're entitled to some compensation for having been subjected to those conditions during that time, from the time you gave notice to the time that the landlord finally got around to fixing the AC. And these are your compensatory damages. But you're still in the unit, but you're seeking relief for those uncomfortable conditions you were subjected to during the time the landlord failed to repair the AC.
Option 3. Now this is one that we would never ever recommend without talking to an attorney because it's complicated. I joked about this PowerPoint when I saw the slide that I don't like PowerPoint slides with a lot of words on it, but on this one there's a lot to cover. So, and I hope it sounds daunting because it is really difficult. So the first thing you have to do is give written notice to your landlord that if they don't make the repair in 10 days, you're going to hire a licensed contractor to repair the air conditioning. This doesn't mean that you can hire a family member or somebody you know who's going to come in and fix the air conditioning. You see your air conditioning not working, you think, well, I know somebody. You can't do that. You've got to hire a licensed contractor. You can check to see if they have their license on the Arizona Register of Contractors, and we have the website right here. We will have this PowerPoint on our website so that you can get this information later. So why I think this is another reason why I think this is not the best option is that I've had air conditioners have to be repaired before, and it is expensive. They're expensive. And you can only use this remedy if the repair costs less than $300 or 1/2 of your monthly rent, whichever amount is greater. For example, if your rent is $700, the repair must stay under $350. And then you can deduct the cost of that repair from your rent payment. That's problematic because most of the time, if your air conditioning is not working, the cost of the repair by a licensed contractor may be more than the amount that's allowed under this. So after they complete the repair, the contractor has to fill out and sign a waiver of lien, which we have a copy again on our website for you, and then provide an itemized bill marked paid. Then you have to give your landlord copies of these documents along with the self-help remedy completion notice and payment of the amount of rent owed. You still have to pay rent, but then you can minus the deduction of the contractor's bill. So I hope that sounded complicated and scary because it is complicated and scary. And I'm not going to make it sound like this is an easy method, right? Stan, how many times have you seen people use this method in your long life of being a tenant attorney?
Almost never. I can't think of when I know I've not counseled anyone how to go through these steps. So Pam is absolutely right. It's complicated and it's not worth a lot of money, as you can see. And the only other thing I would raise, as we said the other day, if you're going to execute this option, you're probably going to have to get the landlord's permission or let that licensed contractor come in and do work in the premises on the AC, because most, in my experience, every time we've dealt with a vendor on behalf of a tenant, they want to make sure that they have the owner's permission to do work on the premises, on the whatever is at issue, because they just feel like there's a liability issue if they're doing work on the premises for something like an AC or plumbing or whatever it may be, and they don't have the owner's permission to be on the premises doing that work.
Okay. Another option which we see people do that is an easier option is you give written notice to the landlord. They have a reasonable time to repair, and if the repair isn't timely made, then you can choose to procure reasonable amounts of air conditioning or cooling for yourself. Does that mean you can go and fix the air conditioning yourself or go get another air conditioning? No. What that means is that you can go get fans. Like when we're talking about air conditioning, you can go get fans and then you can deduct the actual reasonable cost from your rent, right? And then you keep all receipts from these purchases and be able to prove that you purchased the item after the deadline stated in the notice. So if the notice says the landlord's got 5 days to get this to you, 5 days you're going to go buy fans, then you have to wait the 5 days because your receipt has got to show that you actually gave them that time to fix before you bought the fans. You know, this is one of those options where if the tenant really needs fans, that they need to get fans. This is just saying that you're not going to be able to deduct this from your rent unless the cost of the fans was after the time you gave the landlord notice to be able to fix it. Just like the landlord has to have an opportunity to fix it themselves. So can the tenant go buy fans themselves and just not deduct it from their rent? Yes, you can go buy fans if that's what your family needs to have to survive in Arizona summer. You can go do that. You just can't deduct it from your rent unless you do it this method. Stan, do you want to bring some more wisdom in?
Absolutely, Pam. And part of the problem with this is that if you do this and if you take this approach to buy fans or some mobile AC unit because you really need to do so, but if you fail to give proper written notice and then you deduct those costs from the rent and you offer the landlord what you think is the rent, that's a partial payment. And they are not inclined to accept partial payments easily. So you're going to have a battle with that partial payment and potentially an eviction for non-payment of rent. So that's why it's so important that if you're going to take these steps, you've got to document that you did it correctly. And essentially, ladies and gentlemen, you've got to put on a belt and suspenders because you have to do this better than the landlord or the property manager. And if you're able to do that, then you can deduct these costs. If you're not, you are potentially going to be looking at a partial payment claim by the landlord, and they may not accept it, and they'll be looking for full rent, and you'll receive an eviction notice for failure to pay the rent that they believe is due, and you should know this.
All right, we're moving on. I like this option because I think that when it's 100 degrees outside and you have young children or elderly in the house, and it becomes or a health condition like COVID-19, when it becomes that level of hot in your air conditioning, your health is at risk. This is a life-threatening matter. So if you can't afford to go to reasonable substitute housing, meaning like a reasonable hotel, this option allows you to do it. I've seen this option work. But you have to do it correctly if you want to be able to deduct it from your rent. Again, you can always leave your premises and go check into a cheaper hotel or go stay with somebody else. You can always leave your place if it's life-threatening. This option just allows you to be able to deduct it from your rent. So let's talk about it. You got to give written notice to the landlord, reasonable time to repair. And this is one of those ones where if it's life-threatening and you got to give them notice, but some people say it's 5 days. It just depends on how hot it is outside and your situation, right? If it's like the hottest day of the summer and you have young children or people who are ill in the home and they will die, then reasonable notice may be less than 5 days. If the repair is not timely made from the time you gave on the notice, you can choose to pay for reasonable temporary substitute housing, such as renting a hotel room until the landlord repairs the air conditioning in your home. Then you keep the receipts so you can prove that you use the substitute housing only for the time period. You can only get the time period from the deadline stated in the notice until the air conditioning is restored. So what we've seen people do is, it's so hot, you've got to get out of your house, right? You've got to get it fixed. And they leave, they go to a hotel, but the only part that they're going to be able to deduct from their rent is the time after the time that you gave the landlord to repair. So let's say on a Monday, your air conditioning is not working. It's 120 degrees. You and your family check in to a hotel down the street while he's waiting to make the repairs, but you give your landlord notice on Monday and you give him 48 hours to repair it. You're not going to be able to deduct that from your the hotel from your rent until after that 48 hours. So that would be a loss to you. And again, you can't, this is where you think, maybe I'm going to go check into a spa. You can't do that either, because you can only deduct, well, you can, but this is the part that you can only deduct from your rent, a maximum of 125% of your rent amount for the substitute housing. So for example, if your AC is out for a month and your rent's $800, you will be excused from paying the full $800, and you can be reimbursed up to another $200. So that's 800 times 25. So if your AC is out for a week and your rent's 800, because it's 125% and not 100%, you can be excused for up to $250. And so this is just really important. Again, you need to go where you need to go. This is just talking about the amount that you can deduct from your rent. And that's important while you and your family are making those decisions of where you're going to go and what you're going to do, what you can afford. Stan, you want to add to this?
I think same comment, just be careful again, as we've been saying, because this again sets up potentially that situation. It's a partial payment, and the landlord may decide that they don't want to accept your receipts and they want the full amount of rent. But everything else that Pam has articulated, I agree with.
All right. Okay, so remedies are not available if the tenant's family, or guests cause the air conditioning to stop working by a deliberate or careless act or failing to act. So if your family tries to go fix the air conditioning by themselves and they make it worse or they do something to it, then you're not going to be able to get any of these remedies. So don't do it. You probably have that family member who says, I know what to do and fix it. I can do it. Just don't do it, because it's going to cause you more problems in the end.
Pam, can I jump in there before you get to COVID?
Yes, of course.
Recently, the Morris Institute issued their eviction report. I believe it's now publicly available. And one of the points that they've made in that report in the past and today is the issue about habitability, about tenants trying to address the things that we're talking about. And what has struck myself, and I'm sure Pam, is that the justice courts tend to take the tenants' requests for repairs and claims for diminution in value and requests for repairs, and they make the tenant they put the burden on the tenant to really explain and document the basis for the diminution value, the basis for the notice, and is the notice sufficient? And it seems that if they're pro per, it's an extra burden. So the point is, just be aware that these claims, if they come to that in justice court and you're trying to use these options as your defense for an eviction for non-payment, that the courts tend to find more favorably on behalf of landlords and property managers in this area, unless you have really been able to document the things we've just talked about.
Thanks, Dan. So what if the landlord or maintenance person has COVID-19? First of all, they cannot then come into your property. They cannot. So they need to have somebody do your repairs that does not have COVID-19. They have a duty to you for safe and habitable housing. They can't have somebody come into your unit that has COVID-19. They can't say we're not in business because they're essential service. And this is what's really key, is that throughout the country, housing groups believe that because of COVID-19, it's going to be even harder than it normally is to get maintenance workers out to be fixing air conditioning and things that we need. It's really difficult in the summer because there's such high demand that it takes landlords, it's difficult for landlords to get someone there. They anticipate that this summer it's going to take even longer. But that does not take away any of your rights as a tenant. The landlord can't say to you, we're having a pandemic, I'm sorry, I can't get anybody here. Then you still have, that may be, because that could be true, but you still have all of the protections that we discussed. Like the landlord still, just like you as a tenant, still have all the requirements that you are required to do under your lease and under the Landlord Tenant Act. The pandemic does not excuse that. Stan, you want to add?
No, I do not.
All right, then we're going to move forward. So this is some of the guidance that's come out. What should a landlord do to make sure they are safe entering a unit during COVID-19? So, this is for the landlord who is coming in to fix things, who doesn't have COVID-19, and they don't want to get it either. So they need to maintain social distancing of at least 6 feet from the tenants, wear personal protective equipment such as gloves, masks, and safety, wash hands for 20 seconds before entering the unit, do not touch your face, sanitize the gloves, any equipment being brought into the unit, and before leaving, wash or sanitize any surfaces touched during the entry. This is not the law. This is the guidance that's coming down to landlords from the National Housing Centers. So that, again, this isn't the law. This is just guidance, common sense guidance for landlords to protect themselves. So what should the tenant do for all repairs during COVID-19? Same thing, you're going to maintain social distancing, wash hands, contain any pets or service animals from the work area, and make sure that either you or the repair person has cleaned or disinfected the area in which work was done. So what Stan brought up is when you ask for repairs, you're asking for someone to enter your place. You're going to have to grant access to someone to come into your unit. You may choose to not be there in the unit when the repairs are being done. Sometimes that might be during COVID-19 the right answer if you don't want to be near the person making the repairs. Other times, tenants want to be there when the repairs are made so they can see what the person's doing in their unit. But that's the tenant's choice. Stan, you want to add to that?
I believe, Pam, these, as you said, these guidelines are out there from
guidance, not the law.
Guidance. And so if you are a tenant, hopefully we'll have this information up on our website and you can take a look at it for yourself and apply it. And of course, I think it should say masks should be in there. You should be wearing a mask as well. But I completely concur with Pam. These are the things you, the tenant, want to do to protect yourself in the event someone's coming into the unit during this pandemic.
So this is where it gets a little bit harder. What if you or your family has COVID-19? Well, then your landlord may refuse to assist. The landlord attorneys believe there is an Arizona statute that says if you're being quarantined because of a health crisis, nobody should enter your unit. And they also want to protect their landlords, which makes sense. So the landlord may refuse. So a couple things to do in that situation. First, call an attorney. You can call a CLS. The statute, the Arizona statute says the only way that someone then can break the quarantine is if there's an order from the Department of Health Services. So one thing you can do is call the Department of Health Services and say, I don't have air conditioning. It's making the COVID-19 worse. I need help. Can you issue an order that would allow the landlord to enter my unit and fix it? And maybe I will make sure that I'm not in the unit at that time, or the health department's going to say that you can quarantine somewhere else so you can get it fixed. You can call a doctor to give the landlord notice. But we would suggest in that situation to also just talk to your landlord. There might be other options, like maybe you can be placed quarantine in an available unit while your air conditioning is getting fixed. Maybe there's some other options, but this is where it's going to get difficult. So really reach out to an attorney. And this is only if you have COVID-19. It's not if you are sick with something else or you're not sure if you have it. This is only when you've been ordered to be quarantined because you or your family has COVID-19. Stan, do you want to add?
The only thing I would add is, Pam said, this is a different area because now the property manager is saying that they cannot come in because of this quarantine situation. If you can demonstrate to your doctor's healthcare provider that in fact the quarantine has been lifted or it's close to being lifted, and that their view of you as because of your diagnosis of COVID-19 may be that they feel you're disabled when in fact you're not, you may have some rights under the Fair Housing Act to demonstrate that there is unlawful discrimination taking place because you're not being provided the same terms and conditions of a dwelling unit because of this perceived disability. So it's an area where, as Pam says, talk to your doctor, find out if in fact it's okay for you to allow people into the unit, and how soon will that be okay, and let the property manager landlord know that, you know, I'm reaching in this 14-day quarantine period, and that you want those services. And if they refuse, then do as she suggests. And you may also have some rights under the Fair Housing Act, and you might want to reach out to one of the fair housing organizations in this area. And I believe that would be the Southwest Fair Housing Center, and they might be able to guide you regarding the landlord's perceived regard for, or belief that you have a disability, which you may not in fact have, and you're being treated differently because of it.
Good advice. So, one extra requirement because of COVID-19, it's not, I mean, this is the requirement always, landlords must keep the common areas clean and safe. So that means that they've got to sanitize those common areas to make sure that the common areas are not spreading COVID-19. For instance, if you know somebody in your apartment complex has COVID-19, then you're going to be worried when you're in those hallways or touching the common areas. So one thing you can do is contact your landlord and talk to them about it and say, what steps are they taking to clean and sanitize the common areas? So from keeping COVID-19 from spreading. And as a landlord, I mean, landlords should want to keep their common areas clean and not have all of their tenants with COVID-19. So this is one thing that landlords are going to have to make sure they're doing this summer as we keep going through this pandemic. And tenants should have a discussion with them about the practices of the sanitizing the common areas. Okay, so we are at questions. The question is, where can you find the city codes on temperatures? I can't find it. Stan, you want to answer that?
Off the top of my head, the only thing I can suggest, and I'm going to use my experience in the city of Mesa when CLS had an office there, I would reach out to the city inspectors, building codes department, and look on the website for the city's building codes and see if you can find it there, or just contact the building department, the code compliance department, and tell them about your concern and ask them to come out and investigate your belief that the unit's too hot. And perhaps by a search on their website, you might be able to find the information regarding what would be the appropriate temperature in the city of Mesa for an AC unit. But off the top of my head, I can't tell you exactly, other than going to an entity like that. That's where I would go. That's where I would start. And I would start in any city: Tempe, Phoenix, Mesa, Scottsdale, all of those code compliance organizations, their building codes, that information should be available on their website.
That's right. That's where I found it before, is on their websites. Well, I don't know what city you're looking for, but most cities should have it on their website. You can find the city codes. And to be honest, they do vary. Oh, so City of Phoenix Neighborhood Services Department enforces the AC code compliances. So that's great. So if that means that we gave those numbers for Phoenix, if the air conditioning isn't working, and it's a city code violation, then you can call the City of Phoenix Neighborhood Services. And then she says for the multi-housing units. So that's really important. But like other cities have the number is not the same for every city. Some cities the AC code compliance, the temperature can be higher than it is in the city of Phoenix. So you need to go onto the website to look at that. Again, if the air conditioning is not working, then you have all the rights under the Landlord-Tenant Act. Just to make sure we understand that the code enforcement, like we discussed, oh, good. And now I'm going to tell you how you can look at the city compliance for cities are found on local government websites, like that's what we said. And then the city of Phoenix is City Code 39.5, Neighborhood Services. And then the tenant can request an interior inspection. So again, this is so that if the AC, if it's really in debate whether the AC isn't working, we've seen this happen, right, Stan, where the landlord says, yes, I fixed it, and then they say, no, it's still hot. This is really where you want to go and call your neighborhood services and, like Stan said, and get code compliance out there to say, no, this is a violation of our code, because then you have a third party documenting it, which is really important. And so that we've worked with neighborhood services on that before. But if it's not working, you don't have to do that. It's not working. Like the landlord has a duty to supply this. You can also do all of the options that we talked about. You have rights under the Landlord-Tenant Act. Stan, you want to add to that?
Yeah, I do. Practically speaking, a lot of our clients, at least I know in Mesa, they would go to Home Depot or Lowe's and they would get one of these thermostat things that would measure the heat, read the heat inside an apartment. It would tell you how hot it was. And you could use that information to suggest to your landlord that this is the temperature in the room. And I'm not making this up. This is a valid reading from, this device, and use that also as a way to get your landlord's attention. But I do know you can buy those devices, Home Depot, Lowe's, because I've had clients go and do that and use them to justify their request for having that AC unit fixed.
And so we've worked with Glendale, other cities also on these issues with the air conditioning. You can go, like we said, on the local government websites just to find what those numbers are, but that's where you want to start if you're going down that route. Or call the city's neighborhood services, like the suggestion for Phoenix. If you think that it's a dispute about, you think it's not working, landlord says it is working. Because that's usually what happens, right? You get the repair person there, they come, and it's still not working. And you still have the right to give all of the notices if it's not working, and you still have the remedies that we discussed. Stan, do you want to add any more to that?
No, I do not.
Okay. So, any parting wisdom you want to give, Stan?
No. Well, let me say this.
See, we have a couple more questions, actually. Sorry.
Okay, let's take the questions.
This is a really good question. I like this. 2 good questions, Dan. Are 5 days business days or calendar days?
Calendar days. Everything is calendar days.
Yeah, so if it's a weekend and you don't have air conditioning, you don't have to wait to start counting the days. Oh, here's another good one, Stan. Is food loss reimbursable? Because that's the situation, right? Where you lost food because you don't have air conditioning, or like Stan talks about moving to substitute housing, and you can't, if you move into a hotel, you're not gonna be able to make food. So what do you do, Stan?
Well, are they saying food loss because of loss of electricity, or food loss because?
I would probably say, let's answer both ways. So loss of electricity, food loss. Let's just say they lose electricity and you lose everything in your refrigerator.
I think that's a claim under the statute 33-1361, where the landlord's in violation of a health and safety code, and you're going to try to make that claim for those compensatory damages. But again, you got to give notice, give them a chance to fix it, and document the fact that, well, the problem's going to be, until he is legally on the hook, is he responsible for the loss of food before he has to come out and fix the freezer or the refrigerator? So you may lose some of that food because the landlord has a, day 5 to start, or day 6 after you've given the notice, and he's got 5 days. So the notice says 48 hours, 72 hours. And so on that If we're going to use 72 hours, on day 4, that's when his obligation begins. He may not be responsible for the loss of food for those other days because he didn't know about it. His obligation began on those 3 days, and he has to get it fixed within that time period of 5 days or so. And so that's the time, that's when he might be responsible for compensating you for that loss of food. So you may have to eat some of that. The same would apply if you're out in if you're in your substitute unit and you're out buying additional meals because you can't use the unit. You can make those expenses for having to buy meals away from home part of your claim for damages related to the failure to provide the AC, and you're in a hotel and you can't make meals at home, so you're having these out-of-pocket expenses as well. This is an area where you can make these claims and do the best you can with them, but expect some pushback because they're going to want to minimize what they're going to reimburse you for.
What are safeguards against retaliation against undocumented immigrants and refugees?
You want to take that, Pam?
Well, first of all, the Landlord-Tenant Act applies to everyone, no matter what, right? That Landlord-Tenant Act applies to everyone, whether you're legally in the United States or not. That's the first thing. There is retaliation statutes, right? Stand under the Landlord-Tenant Act.
Right, absolutely.
They can't, if you complain to a government agency, let's say you complain to the neighborhood services about your air conditioning, they can't then retaliate against you. However, having said all of those things, a landlord can always, there's nothing prohibiting a landlord from issues involving status. The Landlord-Tenant Act doesn't apply to that. So we have seen landlords threaten tenants before in these situations, but the tenant should know they still have all of the protections under the Landlord-Tenant Act. If a landlord starts taking advantage of a tenant because they're an immigrant or refugee, that tenant really should reach out to agencies such as Catholic Charities immediately. If a landlord starts threatening a tenant, they should reach out immediately to a nonprofit like Catholic Charities.
And as Pam said, under the retaliation section of the Landlord-Tenant Act, it's very, very narrow. The only thing that really is going to help you is the section where if you complain about a landlord's failure to meet his obligations under the initial slide where we talked about maintaining the unit, taking care of the unit and providing the necessary utilities, that's 33-1324. That's the only thing that really is going to help you, because the other sections have to deal with you becoming a member of a tenants union or complaining to a government agency charged with the responsibility for enforcement of the Wage Price Stabilization Act. I still don't even know why that's in there. So it's a narrow statute regarding retaliation.
Well, Stan, and also wouldn't there be fair housing issues if a landlord discriminates based on a person's immigration status?
Yeah, there would be. That would be another question we'd want to get into as to whether or not that you're being treated because of your national origin discrimination. Yes.
So that might be an option in that situation. Right. We could look at.
But there's there was something else about that question. I can't think of it now, but that's a good question. And so I think those are the only answers I can come up with right now. And but certainly, and we do see that. We definitely see that a lot, particularly in mobile home cases, that people are being squeezed because of their immigration status from bringing complaints under the Mobile Home Act and Landlord-Tenant Act.
Let me just give it one more minute because we are getting, oh, here they come more. Okay. I like this question. If on a month-to-month lease, can rent be raised after an air condition issue?
Probably if they give proper notice.
You're right. So that, I was just going to say, it really comes down to, is there proper notice? So One issue is, let's talk about retaliation though, Stan, right? So if you made a complaint to someone like neighborhood services, and then the landlord raises your rent immediately afterwards, there's a presumption of retaliation. However, if the landlord gave you proper notice of a rent increase, that's probably going to stand, right, Stan?
Well, there's a 6-month period for a presumption in the statute that if you take these actions and they occur within 6 months and you're complaining about the AC unit, something like that, that is a presumption that that action taken to raise your rent was because of the fact that you went to neighborhood services, complained about the AC, and then a month later they decided to increase your rent by 200%. So within that 6-month period, it's a presumption of retaliation.
CLS would look at that case then. If that happens to you, it happens to someone you know, we would definitely look at a retaliation case, an issue with that, like that, because of that presumption. All right, let's see if we get any more questions. These are great questions though, right, Stan?
Oh, they're fantastic.
Challenging. All right, let's just give it one more minute. But you know, you can always email us at that Zoominar email with these types of questions. They get sent to us and we answer them all the time. We can answer any type of legal information question that you're asking here. We just can't give you legal advice. Oh, okay, here comes another good one. Does that increase in rent have to be in line with others given out to other tenants?
That's a good question. That would be a way, one, if it's within that 6-month period when you complain about the AC, and then again, if your landlord decides they want to increase your rent by, again, 400% or $300, whatever it is, and you think it's, you know your neighbor received a rent increase and their rent only went up $50, that's all part of the analysis as to whether or not it's a presumption, but is it because of you complaining about what took place and they just raise your rent beyond something that's within the range of what they've done for other individuals? And that would be part of the analysis and our way to try to build a case that, yes, you may have the right to do so, but why is this gentleman paying a lot more? And on top of that, as Pam said about fair housing, this person happens to be here illegally, supposedly. They're from another country. Are you treating them differently because of their national origin status? Are you making the terms and conditions of that dwelling unit different from them because of their national origin? And as a result, violating fair housing laws as in addition to the Landlord-Tenant Act. So those are all things in the mix that we could look at to see if in fact you've got a cause of action here under both the Landlord-Tenant Act and possibly a fair housing violation. No guaranteed answers, but it's things that we would certainly want to look at and consider for you.
While we're just waiting to see if there's any more questions, I'll just do a little advertisement again for next week. Thursdays are going to be a really good one at noon on the laws concerning going back to work. There's a lot of questions we're getting about that at CLS right now, like what the employer has to do to make sure that the working space is safe. And so we can talk about that and how it impacts unemployment that you might be receiving. So that will be Thursday at noon, and you can sign up for that by going onto our website. And then Friday we'll do Landlord-Tenant Act. We anticipate that the courts will be sending out best practices about evictions during COVID-19. We think that will be coming out very soon. So we believe there will be some guidance and best practices discussions that we can talk about next Friday with a little bit more guidance from the courts. And so that's happening. I don't see any more questions. I hope everybody has a really wonderful Memorial Day weekend, and stay safe and stay healthy. Thanks, Stan, so much for giving us your wisdom today.
Not a problem. Thank you very much, everyone. Have a good weekend. Be safe.